esteemed scholars, distinguished guests, and our esteemed chief guest. Today, I stand before you on this momentous occasion as we gather to celebrate the release of the most awaited Handbook of International Environmental Law published by Thomson Reuters, edited by the visionary minds of Professor Dr. Dilip Ukey and Professor Dr. Anil Variath. Our chief guest today, Honorable Shri Justice Bhushan Gavai, Judge Supreme Court of India, Senior Advocate Nitin Thakker, and Ms. Els Reynaers Kini, embodies the spirit of innovation, dedication, and commitment to our environment. Their gracious presence graces this event with a touch of excellence that resonates with the very essence of this handbook. As we embark on this celebration, I would like to give a brief introduction about MNLU Mumbai. MNLU Mumbai, established in 2015, is one of India's leading national law universities. MNLU Mumbai was established with a commitment to foster an environment of excellence in research, scholarship, education, and justice. The prime goal of the university is to disseminate advanced legal knowledge and processes of law amongst the students and impart in them the skills of advocacy, legal services, and law reforms. MNLU Mumbai believes in the value enshrined in the Indian Constitution, that is justice, liberty, equality, fraternity, secularism, humanism, etc., and makes all our efforts to inculcate them amongst its students, staff, and others to make this institution not only a center of legal knowledge but also a comprehensive center of humanity. With this, I would like to graciously welcome all of you to release of a book of International Environmental Law and also the launch of Postgraduate Diploma Programme in Sustainable Development and Environment. The Justice M.L. Pendse Chair in Environmental Law advocates the laws that will sustain ecosystem and ensure a healthy environment. Further, the Chair is committed to environmental protection, social justice, and public legal education, and also plans to continue its work to protect the environment and the rights related to a healthy environment, and to expand its work to address new environmental challenges such as climate change. On behalf of the entire MNLU family, I express my deepest gratitude to our chief guest for gracing us with their presence and wisdom. Your contribution enrich the occasion and illuminate the path ahead. And to Dr. Dilip Ukey and Dr. Anil Variath and all the contributors, may your work continue to inspire us to strive for a world where the delicate balance between law and environment is upheld and celebrated. Let us start the occasion by lighting the lamp by our esteemed chief guest. I request Professor Dr. Dilip Ukey to felicitate our guest, Honorable Shri Justice Bhushan Gavai. I request Professor Dr. Anil Variath to felicitate our guest of honor, Senior Advocate Nitin Thakker. I request Professor Dr. Dilip Ukey to felicitate our guest of honor, Els Reynaers Kini. In the pages of this handbook, we find the culmination of efforts from scholars across the globe. With the guidance of our esteemed chief guest, we can turn these pages into a roadmap for informed action, a blueprint for collaboration, and a testament to the unity that can be achieved in the pursuit of a healthier, greener planet. Now I'd like to invite Assistant Professor Mr. Adithya Variath for the introduction of the book.
A very good morning to all of you. Respected dignitaries on the dais, His Lordship, Honorable Justice Bhushan Gavai sir, Honorable Advocate Nitin Thakker sir, Ms. Kini ma'am, our respected Vice Chancellor, Professor Dr. Dilip Ukey sir, our Registrar, Dr. Anil Variath sir, members who are going to take part in the panel discussion, all the panelists for the panel discussion, which will be followed by this particular program, all other faculty members in the legal fraternity, students, and all other dignitaries from the galaxy of the legal fraternity. In 2009, there was one animation movie in which it was shown that ice on the Antarctica that is melting, rivers are flooding, heaps of waste that is escalating, people are dying because of unknown diseases. This was a fantasy. But with passage of time, now we have reached to that destination or a moment when few amongst these things are really happening. And it is very well said, when there is a less difference between a fantasy or imagination and a reality, it means the social and public health of that society is in doldrum. And that's why concern for environmental law, that is extremely important one. Now days are gone when it was denounced by saying that this is a fantasy or fanatic thinking of few elite, and now it has become a mainstream thinking and academic seriousness with which this particular issue that is addressed. Adam Smith has very meticulously quoted, and I quote, "Man cannot live without a water, but water has no value. Man can live without a diamond, but diamond is invaluable." This is the paradox of the age in which we are living in. And that's why concern for environmental law, that is extremely important one. So today's program, that is the release of a handbook on international law, which is edited by our visionary Vice Chancellor, Professor Dr. Dilip Ukey sir, and Professor Dr. Anil Variath sir. It is not just a release of a book. What one book can do, I will cite one example of 2002. Prior to that, there was a narrative which was set at the international domain that developing nations or underdeveloped nations, they are contributing in carbon emission. And developed nation, they have no role to play in reducing the carbon emission. There was one book which was published by Sunita Narayan by Center for Science and Environment in 2002, an entire narrative in the field of environment and especially the carbon emission that was changed because of book titled Green Politics. So what one book can do, this is the magnum opus, this is a litmus test to understand that. I am really confident that this particular book is also having, if you just glean through the pages and the topics which are covered right from the tribal rights and the knowledge till the transfer of technology and lot many things which are covered in this book. So definitely this book is going to set a milestone in the history of the environmental law. There is a panel discussion on e-waste as well, and we are also launching a postgraduate program in sustainable development and environment, which is of a contemporary value. So definitely environment, which is playing a very significant role, and we need to definitely be responsive to it. And I'm really thankful to our chief guest, Honorable respected Bhushan Gavai sir, because in 2020, Tata Housing Development Company Limited versus Alok Jagga, 2020 judgment, page of 784, in which he has categorically mentioned that if the construction work near Sukhna Lake, the catchment area, which is just 123 meter from the catchment area, and there is a wildlife sanctuary as well, so that we cannot tolerate, that we cannot go ahead with. So sir's commitment and seriousness towards environment protection, that can be seen through the pages of this particular judgment of Honorable Supreme Court. So sir is releasing this book. This is really a proud moment in the history of Maharashtra National Law University. So I will not take much of your time because all other guests are there. But I just want to conclude by saying that we can forgive a child who is afraid of darkness. We can forgive a child who is afraid of darkness. But real tragedy of the world is men are afraid of light. It should not happen. We should continue with having that particular searchlight in our hand and continue to ignite the minds of the people for protection of the environment. Thank you very much.
I thank our Head of Department, Professor Dr. Pratap Salunke, for enriching the welcome address. Now I would like to invite Assistant Professor Mr. Adithya Variath for the introduction of the book.
His Lordship Honorable Shri Justice Bhushan Gavai, Honorable Vice Chancellor Professor Dr. Dilip Ukey sir, Senior Advocate Nitin Thakker sir, Professor Anil Variath sir, Els respected guests, including faculty members, heads of law schools, my colleagues and my dear friends. Today it is both an honor and a privilege to introduce this book to all of you. I am standing here not just as a faculty member of MNLU Mumbai, but also as a contributor to this work. And I believe that I resonate with the passion and commitment all the 50 contributors had while making this project a great success. So my duty here is not to tell you what is the content about the book. So my duty here is to tell you about the context about the book, to answer the why and how behind this book. So the book that we'll be releasing today represents not just a compilation of chapters written by scholars across South Asia, but it is a beacon of knowledge, an insight that talks about problems, an insight that talks about vulnerabilities, an insight that talks about inequalities. One of the fundamental idea of this work is to expose the inequalities that are present and prevalent in the discourse of making of international environmental law. So if you see that, as Professor Salunke sir also talked about this idea about global north, you actually see that it is estimated that around 92% of the greenhouse gas emissions are emitted by global north states. And the same very high polluters have called upon rest of the world to reduce their emission level, which would entail curbing our levels of development, which would entail curbing the ideas and economic growth that we'll be having. Moreover, while corporations and governments from the global north have exported their climate offprints by setting up countries in the global south, by ensuring that our labor standards are reduced, by ensuring that we produce for them, what we forget to acknowledge is the growth of this idea called as climate colonialism. We are living in an era of colonialism, and that is the era of climate colonialism. The exclusion of global north in the conversations and negotiations of international environmental lawmaking is the underlying theme of this book. And you will see that the book represents these kind of stories, wherein we are talking about inequalities that exist in environmental lawmaking. Millions of people in low and medium income countries will soon see the extreme effects of climate change. And if you see, climate change is called as the biggest threat to public health. We will see in this century that climate change will disproportionately affect the most vulnerable people in the society. And the most vulnerable are the global south, including India. And when we are excluded, when our voices are silenced, our experiences go unheard, what happens for real is that the reality of climate situation in global south is blurred. The exclusion becomes refusal, a refusal to acknowledge the proximity of climate change that the global south will see in the coming few years. And the global north casts climate change as a problem of future, wherein millions and millions of people are dying in the global south. We in India have experienced most morbid of climate calamities in the menu, ranging from floods, landslides, cyclones, and whatnot. We know how it feels to be victims of climate change. We know about the crisis in numbing details. Now the real question is that, what can academics do? What is the role of an academic when we talk about climate change? We can talk, we can write, we can deliberate, we can build deliberations, we can build discourses, we can facilitate action, and most importantly, we can act. I believe that it is our academic social responsibility to respond to this crisis. Focusing on these themes and the nature of the problems, Professor Dr. Dilip Ukey sir and Professor Dr. Anil Variath sir bring to us this new narrative about international environmental law through this book. This book responds to crisis through an academic deliberation. This book is the voice of the global south. This book is a voice coming from the global south, talking about problems of the global south. This book has over 50 contributors. 50 contributors ranging from different parts of South Asia, ranging from academia, think tank, economist, and lot more. And if you talk about the chapters, you will actually see that all of them have narrated their own stories about their approach to environmental law. All of them bring different cultural, socio-economic, and ecological perspectives to the table. I believe that their insights can help us to address blind spots and biases that exist in the normative making of international environmental law. But if you read all the chapters, you will see something very common. There is a sense of commonality in all the chapters, and the commonality is the voice of empowerment. So the book actually represents the voices of empowerment of scholars writing about environmental law in the global south. So when global south thinkers and global south scholars participate in the global discussions on environmental protection, it fosters a sense of empowerment and representation of their communities. And this representation is crucial to address a lot of problems that we see today. So I believe that this book is a movement. This movement is to call for action. Its contents serve as a reminder that each one of us hold a stake in the fate of our planet and the legacy that we'll leave behind. I still remember the day when we started talking about this book in Professor Dilip Ukey sir's cabin. And I still have an emotional connect with the book because it was a very small dream that we had of bringing out this book, getting scholars from around the world writing for the book. And it was actually a very small dream that Professor Anil and Professor Ukey sir dreamt of. And now I believe that the book is no longer your dream. Now the book is the dream of the contributors who are the real stakeholders of this project. We have taken over your dream and it is our time to act. And I believe that this book will be the roadmap for action, not just for literature, but roadmap for action. Okay. I hope you have a wonderful time reading the book. I'll recommend all of you to buy the book. I'll recommend all of you to suggest the book and also read the book for our future. Thank you so much.
Now I request Honorable Shri Justice Bhushan Gavai sir, our respected Vice Chancellor Dr. Dilip Ukey and our Registrar Dr. Variath and other guests to officially release the Handbook of International Environmental Law and also to launch the 1-year PG Diploma in Sustainable Development and Environment. I would like to call on stage Assistant Professor Dr. Garima Pal to introduce our guest of honor, Ms. Els Reynaers Kini.
A very good afternoon to all the dignitaries present at the dais and the lovely audience. Ms. Els Kini serves as a partner at MV Kini Law Firm, where she holds a firm's environmental practice specializing in environmental law and nuclear law. With an academic journey that transcends continents and legal ranks, she holds law degrees from Free University of Brussels, Belgium, and the University of Delhi, India. She further enhanced her legal acumen through an LLM degree at University of Georgia, USA, where her thesis explored the integrated regulations of transboundary movement of hazardous wastes. Before her endeavors in India, ma'am honed her legal skills at distinguished institutions like Allen and Overy in Brussels and Gordiana and Associates in Chicago, USA, working on environment and energy-related matters. Her dedication to her field has been exemplified through her leadership at the Energy Resources Institute, TERI, New Delhi, where she headed the Center for Global Arguments, Legislation and Trade. This role provided her with a platform to delve into significant environmental and energy-related issues. Ma'am's scholarly contributions have extended to a monogram on the precautionary principle and a steady stream of insightful articles addressing current topics within the environment and nuclear energy domain. With a rich academic background encompassing the Free University of Brussels, the University of Delhi, and the University of Georgia, her intellectual journey has been guided by the luminaries in the field, including her LLM supervisor, Professor Thomas. Her professional repertoire boosts her encouragement with prominent clients, including Amazon Web Services, Meta, Hewlett Packard Enterprise, British Telecom, Abbott Healthcare Private Limited, Bharat Serums and Vaccines Limited, Nuclear Power Corporation of India, Sandvik, First Scholar, and Cargill. Ma'am stands as a beacon of legal proficiency, bridging continents and legal disciplines with her unwavering commitment to environmental and nuclear law. Her scholarly endeavors, diverse experiences, and engagements with prestigious clients embodies the essence of excellence in the legal profession. Ma'am, it is an honor to have you with us. Thank you.
Most kind for this detailed introduction, and I'd forgotten half of what you mentioned, so thanks so much. But many thanks for this kind invitation to be here on this dual celebration of course, the launch of the book. And I think the book is not just the book, it's also a call of action. And then, of course, also for this unique and I think very much needed postgraduate diploma in sustainable development and environment. I think a very good addition to the to the legal field in India. It's an honor to be here today, of course, with you, Honorable Justice Bhushan Gavai, Senior Advocate Nitin Thakker, Professor Dr. Pratap Salunke, Professor Dilip Ukey, Professor Gigmon VS, Assistant Professor Adithya Variath, all the other dignitaries and all the enthusiastic law students of the Maharashtra National Law University here. So let me start by congratulating, because I did browse through the book already, all the professors and the chapter contributors of the exquisite and very topical Handbook on International Environmental Law, as seen and interpreted indeed by the most astute legal brains and insightful scholars of India and the global South. It is indeed, I agree, very refreshing to see these very relevant, topical international environmental law topics being analyzed through an Indian lens, from its history to the underlying philosophy to the key principles of environmental law, as well as the changing role of the state, state liability, environmental impact assessment, human rights, and so much more. It's a very rich book that I'm sure I'll enjoy reading in further detail. So indeed, I believe this Indian lens is so very relevant, as Indian environmental case law and legal reasoning has much to offer from a legal comparative perspective, precisely because it is very proactive and progressive. So it goes to the credit of the Indian judiciary to have been on the forefront of major developments and to have shaped environmental law since the late 1980s. Because at times we take some aspects in our legal landscape, and I say our legal landscape, I mean in India, for granted, because even on date, many petitioners in environmental cases in other jurisdictions, be it in Germany, be it in America, face still procedural hurdles which are unsurmountable. So therefore, the foresight and the pragmatic approach which has been adopted by the Indian judiciary for many years in the context of public interest litigations, including pertaining to the locus standi, which has been simplified to such an extent, isn't it, that any member of the public can petition the court on behalf of determinate class of persons in the case of any breach of fundamental rights, must be applauded, because it is not a given at all when we look at it in other jurisdictions. This is further critical because when one analyzes, for instance, the current climate change cases, it's a very fascinating field to follow, because you have over 1,000 cases being filed in multiple jurisdictions around the world. You will notice that all too often such climate change cases will not see the light of the day, precisely based on the ground that the NGOs or the associations of persons simply lack the necessary standing, for instance, because an NGO hasn't existed for X amount of years, etc. And these are hurdles that you do not find in India. And so this is a struggle for many of these litigants across the globe, because in effect they do raise legal points which are in the interest of the public at large, including at times even the long-term interest in human rights of a healthy environment of future generations. I find equally impressive, and to an extent even much more unique to India, the well-established approach by the Indian Supreme Court, the High Courts, and also the National Green Tribunals is to seize matters suo motu, on their own motion, based on information found in the public domain, most often environmental harms covered in newspaper articles. So this is a very powerful tool of the Indian judiciary, and in a way forges a direct connect between the sitting judges and the concerns of the citizens in India. And I often highlight this to the in-house counsels that I advise of companies who want to do business in India, and invariably this novel concept comes as quite a surprise to them. It is mostly unheard of in other jurisdictions, and even corporate directors very much take careful note of this, and I think this is judicial activism at its best. So moving on from some of these procedural aspects to the more substantive level, as you know, in India, since the Subhash Kumar case in 1991, in the absence of an express fundamental right to a healthy environment cemented in the Indian Constitution, the Indian Supreme Court has based its judgment on interpreting Article 21, which guarantees the right to life, to include right to a healthy, pollution-free, and clean environment. We take it for granted, but mind you, even in relatively recent case, for instance, in 2017, the Irish Supreme Court observed that the Indian Supreme Court was the only common law jurisdiction to interpret the right to environment as a constitutional right without an express constitutional provision. So the Irish Supreme Court further observed that most of the states where the constitutional right to environment was adopted has been achieved by including such wording explicitly and not through expansive indirect interpretation. And yet, I believe this expansionist or even activist approach by our Indian judiciary must be fully appreciated for both its creativity as well as its braveness, for at the end of the day, without it, our society would be worse off. So quite importantly, the distinct legal mindset from the Indian judiciary also has positive influence well beyond India's own borders, including at the International Court of Justice. For example, in the 2018 Costa Rica case, in which the International Court of Justice for the first time ever addressed compensation for environmental damage, issues were also addressed such as the status of the precautionary principle as a binding principle of customary international law. Now in India, I'll quickly go back to India. So in India, as you know, since the 1996 Vellore Citizens Welfare Forum case, Supreme Court has consistently held since then that both the precautionary principle, the polluter pays principle are part of the environmental law of the country, and even ruled that these principles are part of customary international law. So mind you, the International Court of Justice has actually never ruled so explicitly. Precautionary principle, as you know, when broken down in tangible elements, means the following three things. First, statutory authorities, your regulatory authorities, must anticipate, prevent, and address the causes of environmental damage. Second, faced with the threat of serious and irreversible damage, scientific uncertainty should not be used as a reason for postponing measures to prevent environmental degradation. And third, and quite importantly, for litigants, the burden of proof is shifted to the entity undertaking a particular activity to prove that it would not adversely impact the environment. Hence, the precautionary principle also underpins the concept of environmental impact assessment, for instance. So with this, now going back to the Costa Rica case, Judge Bandari from India, in his impressive dissenting opinion, firmly supported a view according to which the growing awareness of the need to protect the environment is shown in the crystallization of the precautionary approach into a customary rule of international law. And that means a binding principle of law, and he referred extensively to Indian case law in this ICJ case. So he further submitted that it would seem appropriate for the International Court of Justice to rely more explicitly on the precautionary approach in future disputes raising issues of international law as well. And I find this interesting because to this extent you see the connection and the relationship between international and domestic environmental law, which in a way operate as informal communicating vessels, where incremental developments in one regime tends to influence also the regime at the other level. So, as the former International Court of Justice Judge Koymans explained, ICJ is actually a collegial body where you have to find a balance between judicial activism and judicial restraint. And at times, at least one wishes, in the interest of the development of international environmental law, that the ICJ would display a similar proactiveness as the Indian judiciary. Now, we spoke on procedural aspects, substantive law aspect. I would also like to touch on environmental compliance landscape in India, because it is undeniable, I think, that environmental governance, that is by the executive branch, its regulatory authorities in charge of enforcement of environmental laws, could and should be made more robust. Let's not forget that I always think India has a large pool of brilliant engineers, environmental engineers, chemical engineers, who actually should be brought into the regulatory fold. This will require a critical rethink on the overall structure and hiring practices of the environmental enforcement agencies, but I think it will be key moving forward. So keeping in mind this afternoon's panel discussion on e-waste, recycling and the circular economy for sustainability, the role of these regulatory authorities, which should be modernized and professionalized, becomes all the more important. This is because a new circular economy model will force a complete new rethink from the private sector. But at the same time, they will need to be supported in this transition by the regulatory authorities, which must function in a more transparent, a more efficient manner, and adopt a more constructive and non-adversarial mindset vis-à-vis, I do think, the business community. Also regarding India's path to a circular economy, the Indian government rather has initiated a dialogue in 2021 and some initial policy steps by nudging various ministries and subject experts to form committees focused on 11 areas, including municipal waste, scrap metal, electronic waste, lithium-ion batteries, solar panels, toxic and industrial waste, end-of-life vehicles, etc. So these are important developments, particularly given, all said and done, the challenges faced in India in the waste management sector. That's a separate discussion in itself, but indeed much remains to be done. So there are nevertheless several positive developments noticeable pertaining to e-waste management in India, I find. So firstly, the 2016 rules have now really taken off, and all the companies as well as custom authorities are now fully aware of the requirements. Unlike, you may recall, the 2011 rules, which simply remained a dead letter. So that in itself is progress. Yet, as the policy paper of the Ministry of Electronics and Information Technology acknowledges, only 10% of your e-waste generated is actually collected for recycling. That also means, conversely, the other 90% of the e-waste generated remains left to its own destiny. So much remains to be done. Secondly, the e-waste rules also have successfully placed the notion of the extended producer responsibility, or EPR concept, center stage, with clear recycling targets for all the companies. So this too creates clarity. And the plastic waste management rules to an extent also have now the EPR very much embedded in it, be it that these targets are a bit less clearly spelled out. So these are positive developments, and I do believe most industries are now fully aware of these extended obligations resting on them. Thirdly, it must be said, as much as I was a bit critical earlier on of the regulatory bodies, the Central Pollution Control Board very much plays a central role in overseeing the enforcement of the e-waste rules, and I must say, and compliment also the CPCB, it has a very dynamic, technically well-versed team in place and runs efficiently, is always ready to offer clarifications to industry. In that sense, it is very approachable. These are very technical matters, but it is willing to share interpretations, because one cannot just derive everything from the reading of the rules, but the particular products are covered by the e-waste rules. There's an exhaustive list, and it's very technical. So the CPCB is approachable, willing to work with industry, and even willing to put so in writing at times, which is highly unusual also for regulatory bodies. So I do feel the CPCB is showing how a constructive approach of these regulatory bodies could be adopted even at state level. Relatedly to the panel discussion this afternoon, I would also encourage all of you to read India's Tryst with a Circular Economy. It's a working paper published by the Economic Advisory Council to the Prime Minister. It was published this April this year, in which it takes stock of where India stands, as well as the policy steps and incentives which are required for India to transit from a linear economy to a circular economy. It is a very well-formulated paper, and not just a paper, I think also looking at all the next generation present here. So a circular economy will offer many new job opportunities to the younger generation, and not just for engineers and MBA students, but also very much for corporate and environmental lawyers such as you. And I can but urge all the students interested in this field to keep track of all these even technical developments very closely, as environmental law indeed very often requires you to be in tune with both policy developments but also these technical developments. And so with this, I would like to congratulate the Maharashtra National Law University once again, not just with this very impressive publication, but also with the much needed postgraduate diploma in sustainable development and environment, which I am sure will prepare the next generation of legal scholars in India and practicing lawyers with the necessary skill sets which are required to take active part in the new environmental paradigm of tomorrow. So many thanks. Yeah.
Thank you so much, ma'am, for such a wonderful address. Now I would like to call on stage Mr. Shyam Gulve to introduce our guest of honor, Senior Advocate Nitin Thakker.
Senior Advocate Nitin Thakker's contribution to the legal profession are characterized by brilliance, unwearying dedication, and an unyielding commitment to justice. His illustrious career has firmly established him as an icon in the sphere of legal advocacy. As a seasoned legal practitioner, Nitin Thakker has demonstrated a profound grasp of intricate legal complexities and a remarkable ability to navigate complex legal terrains. His expertise stands as a testament not only to his profound knowledge, but also to his relentless devotion to upholding the tenets of justice. His advocacy skills, honed through years of practice, have earned him a reputation as a formidable presence within the courtroom. His capacity to deconstruct legal arguments, present compelling cases, and offer insightful perspectives sets him apart as a legal professional of extraordinary caliber. Furthermore, Nitin Thakker's dedication to legal education and mentorship has been instrumental in nurturing the growth of aspiring legal minds. His guidance and mentorship have played a pivotal role in shaping the future of legal fraternity. It is noteworthy to mention that Nitin Thakker's contributions extend beyond his legal practice. He has been a steadfast pillar of support for Maharashtra National Law University Mumbai, offering not only his endorsement of our indoors, but also providing invaluable guidance to both students and administration. His willingness to share his insights and wisdom has been instrumental in guiding our institution towards greater heights. Thank you.
Namaskar. The Honorable Mr. Justice Bhushan Gavai, the Judge Supreme Court of India, Professor Dr. Dilip Ukey, Vice Chancellor of Maharashtra National Law University, Professor Dr. Anil Variath, Registrar of Maharashtra National Law University and Chair of Pendse Foundation, Ms. Els Kini, Faculty of Maharashtra National Law University, the panelists for today's panel discussion, Mr. Shri, the President of Family Court Bar Association, the faculty of Maharashtra National Law University, students of Maharashtra National Law University, invitees, ladies and gentlemen. It is an honor for being invited at the book release function of Handbook of International Environmental Law, edited by Professor Dr. Dilip Ukey and Professor Dr. Anil Variath, as well as launch of one-year postgraduate diploma in sustainable development and environment. I am thankful to the university, Dr. Ukey and Dr. Variath for inviting me. My heartiest congratulations to Dr. Ukey, Dr. Variath for compiling and editing the Handbook of International Environmental Law, presenting the viewpoint of, as Adithya put it, Global South with international perspective. The university also deserves pat on its back for commencing the postgraduate diploma in sustainable development and environment. I was wondering over the last 2 weeks what to speak for today, and I was trying to put my thoughts together. As a second speaker, it is always very difficult. We don't know what first speaker is going to speak, and I should not tread on what Justice Gavai is going to speak. And luckily for me, I am in habit of reading news from the portals. I came across 2 days ago a news report on CNN portal, which stated that the headline was that America's richest 10% are responsible for 40% of planet's heating pollution, and there is a report which was mentioned in that news article. It made me curious to read the entire story. The report states that wealthy Americans who fly their private jets and indulge in all sorts of luxuries and who invest in corporation and industry all over the world which pollute and generate carbon are responsible for global warming to the extent of 40%. Just imagine 10% of Americans are responsible 40% of global warming. And that's what that report of an American professor says. The report advocated that instead of taxing on the carbon intensity of what people pay by taxes, government should focus on taxing climate polluting investment instead. So instead of taxing people individually, you please tax these investments where they invest in global polluting industry. This made me realize that it is our duty as an individual and responsible citizens to see to it that we do not pollute and we protect our environment. I also felt that it is not enough to study sustainability and environmental law, but it is necessary to educate our fellow citizens. It is also necessary to take a stand and lead against climate change. Yesterday morning, I read another news item in our local newspapers, which was really heartening. It concerned our neighbor Bhutan. And the news item stated that Bhutan has emerged as a country with net zero carbon emissions. The news report also states that Bhutan has transformed into a carbon sink, absorbing more carbon dioxide, CO2, than it releases. I do not know when or if at all we will become, that is India will become carbon sink. But we could certainly attempt. I wish we all become responsible citizens and emulate Bhutan. Collective awakening of our consciousness is needed. The nations are meeting and discussing and signing treaties to protect environment, but still the results are not seen. We have seen and read about more hurricanes, storms, excessive rains, flooding, landslides. Cities across continents are reporting great flooding. We see that China, some cities are flooded, in America, in Europe, the cities are experiencing unusual floods. The heat waves, the temperatures going more than 50% in several now, it is not confined to deserts, but now some cities are having temperature of more than 50% in summer. Wild forest fires, because all year round we see sometimes when the summer is in south, and Australia, New Zealand report wildfires, and now Canada, USA and European cities are reporting wildfires. Reduction of glaciers in South Pole, but still we only discuss and say it is El Nino effect or it is global warming. I think some drastic steps are required, and if they are not taken in time, we are racing towards the doomsday at a rapid speed. Our government has been conscious about the same, and by 42nd Amendment to the Constitution of India way back in 1976, it was incorporated in Constitution a provision explicitly for environmental protection and improvement. Article 48A, which was introduced then, provided that the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife in the country. Article 51A was also introduced, and it provides the new chapter entitled Fundamental Duties, which imposes a similar responsibility on every citizen as a duty to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. The government has over the years enacted and or amended several laws to protect environment, issued CRZ guidelines and much more, created green tribunal. But what we have done, the industry and individuals have seen to their own benefits and profits. They tried to bypass or commit breach of laws. Our constitutional courts, led by the Supreme Court, has jealously protected our environment. Our chief guest is one of them, who has passed several orders, including while heading the Green Bench. Justice Pendse was that fearless judge who, during his tenure, through various judicial orders, even before the era of PILs, protected environment. Justice M.L. Pendse Foundation is very happy to associate itself with Maharashtra National Law University in establishing this chair in environmental law. I am glad that MNLU is starting its postgraduate diploma course in sustainable development and environment. This type of courses are need of the hour, and I am sure the student community will take full advantage of the opportunity made available. There are committed individuals and NGOs who have championed the cause of environment. There is bound to be debate between sustainable development and environmental protection. It has to be tackled on case-by-case basis. I wish the postgraduate students should guide such individuals and NGOs in arriving at a rational decision. In a way, we all are contributing to global warming, knowingly or unknowingly. Professor Jared Starr, a sustainability scientist at University of Massachusetts and one of the authors of the report which was published in CNN, has stated, and I quote, "Global warming can be this huge, overwhelming, nebulous thing happening in the world, and you feel like you have got no agency over it. You kind of know that you are contributing to it in some way, but it is not clear and quantifiable," unquote. It is high time that we vow to become responsible, to protect our environment, and be there to change the world. In words of Margaret Mead, never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has. Thank you.
Thank you, sir, for such a special address. Now I feel honored to move towards the introduction of one of the visionary minds behind the book, our Vice Chancellor, Professor Dr. Dilip Ukey. And I request Dr. Abhijit Rohi to give a brief introduction about our respected Vice Chancellor, sir.
Thank you, Richa. You said brief. I'll try to be brief. There's a lot of things that I probably could talk, so I'll try and keep it very short. So, a very good afternoon, everyone present here. I deem it my privilege to introduce our Vice Chancellor, Professor Dilip Ukey. Prior to his tenure at MNLU Mumbai, he served as Pro Vice Chancellor and Acting Vice Chancellor at SRTM University, Nanded in Maharashtra. He served as a Professor of Law and also has headed the Department of Law at University of Pune. Professor Ukey has contributed significantly through his association with esteemed organizations such as UGC, NAC, UPSC, and various state public service commissions across India. He is a nominated member of UGC MHRD panel of experts concerning institutions of eminence in India. He was appointed as a visiting research fellow by the University of New South Wales in Sydney and was the recipient of UGC fellowship for research visits to France. Professor Ukey was invited to share his expertise in the domains of jurisprudence, constitutional and human rights law at various international conferences organized by universities across the globe, including University of New South Wales in Sydney, Vienna University, Austria, City University, Hong Kong, and Kathmandu University, Nepal. Professor Ukey was honored with the title of Best Academician Law by Indian National Bar Association, New Delhi in 2019. Indeed, of course, a very well-deserved honor. His research papers and books are widely acclaimed and read within academic circles. In 2020, a book authored by him titled Jurisprudence of Legal Theory was also published by Thomson Reuters. Today, with this book, one more has been added to his collection. That's with academic side, but administrative side also I should introduce. Under his leadership as the Vice Chancellor of this university, MNLU Mumbai has made a lot of academic and administrative progress. The same can be seen in the increased student strength, starting novel and innovative degree and diploma programs in the university, establishment of numerous specialized research centers, just to name a few. His commitment to rooting out administrative adhocism and streamlining the functioning of various departments in this university is unmatched. Due to his leadership and the tireless efforts, MNLU Mumbai has now secured the land for establishing its permanent campus in Mumbai. He said, and I quote, "आप मुझे campus दो, हम आपको number 1 education institution देंगे." This shows his vision, his commitment and confidence he has posed in each one of us. I'm sure under his guidance we will deliver our promise to be #1 legal education institution. Lastly, I must mention that he has written the preamble of the university, which you may find in all the corridors of the university, which sets the goals and values for us as the members of MNLU Mumbai family. And definitely as Karta of this family, he is leading by example. He, through his actions, motivates us all to live by the values and commit to academic as well as professional excellence. So it is my privilege to invite Sir to deliver a presidential address. Members of the gathering, our beloved Vice Chancellor.
Chief guest of today's program, our guide, a mentor, and pillar of our strength, Honorable Shri Justice Bhushan Ji Gavai Sir, Judge Supreme Court of India and Chancellor, Maharashtra National Law University, Nagpur. Senior Advocate, Advocate Nitin Thakker, Ms. Els Kini, Registrar Dr. Anil Variath, other dignitaries who are present over here, all my colleagues, staff, students, friends, and ladies and gentlemen. Very good afternoon to all of you. As I said that while addressing Honorable Justice Gavai Sir, our mentor, guide, and pillar of our strength, except Registrar, nobody knows. I did not reveal, did not share with anybody till now. And today is an occasion to share with all of you that as Dr. Abhijit Roy has mentioned, that university has got granted a land by the government to construct its own campus. But that has been done just a few months before, two and a half months before. Let me inform you all and share with you all that it was last year, precisely 10th July 2022, there was a program of inauguration at MNLU Nagpur, wherein the Road Transport Surface Minister, Government of India, Shri Nitin Gadkari, Deputy Chief Minister of Maharashtra, and then there was only one, Shri Devendraji Fadnavis, who was there. And I used to have the continuous interaction with Honorable Sir. And then he told me that come down to Nagpur, we'll speak to the Deputy Chief Minister. I went to Nagpur on 10th July 2022. Once program was over, Sir has introduced me to the Deputy Chief Minister, Mr. Fadnavis, and told him that help Maharashtra National University, Mumbai as well, because still they are struggling about the land. Deputy Chief Minister has asked me, where is that land? I told him about the present land. The further question was that, is that land acceptable to you? I said, without even a fraction of a second, yes. Because beggars don't have any choice. That's true, because we have been struggling of all those years. And coincidentally, few years before, I had visited that land along with erstwhile Registrar and found that it is suitable for the university campus, and that's why the process for allotment of land was started from 10th July 2022 with the intervention, guidance and direction of Honorable Justice Gavai Sir. Sir, whole MNLU Mumbai, all of us are not only grateful, we are indebted to you. Not only that, we look forward because now land is allotted. What thereafter? So even for further growth, infrastructural growth, we'll look after, and we are confident, not only hopeful, we are confident that with your intervention, with your guidance, government will be generous enough, like MNLU Nagpur, even for MNLU Mumbai as well. The reason I tell you, it is not just a confidence, it is not just a hope, it is a reality. Why? Because, let me quote Honorable Sir himself, which has been narrated by my counterpart from Nagpur, that in that program thereafter itself, he made a statement that now first phase of MNLU Nagpur is over. Hereafter, whatever the help, financial grant, it shall be directed to Mumbai as well as Aurangabad. So though he is a Chancellor of only MNLU Nagpur, yet he takes care of even other two MNLUs as well, and that's why his contribution in growth and development of Maharashtra National University, Mumbai, is really noteworthy. Dear friends, as Mr. Abhijit Roy has pointed out, that the university stands today academically somewhere. 4.5 years before, we had only 2 programs. Today we have more than 12 programs, including MA, including MBAs. This year we have started 4 LLMs, and when there was not a single diploma, now we have 10 diplomas. This is not an occasion or time to speak about the growth of the Maharashtra National University. I must admit at this juncture that in this endeavor, all the stakeholders, they have helped us, guided us, and they are guiding us. As Senior Advocate Thakker sir has pointed out, that then only in 2019, in one of the meeting, as I said even in the past, I made an appeal, and he responded to that appeal, donating 2 crores for instituting the chair in environment law in the name of Justice M.L. Pendse. Now sir is the chairman of Bombay Bar Association. He being the chairman of Bombay Bar Association, president of Bombay Bar Association, I look forward for further extension of help from Bar Association as well as the office bearers and his senior colleagues from Bar Association to Maharashtra National University, Mumbai. Dear friends, this is an occasion which is an emotional one as well as an academic one. On behalf of all of us, once again, I warmly welcome Honorable Shri Justice Bhushan Ji Gavai sir, other guests and dignitaries on this auspicious occasion. And once again, I express my sincere gratitude on behalf of all of you to all the dignitaries and Honorable Justice Gavai sir. When this journey was started, as Advocate Nitin Thakker sir has pointed out about the United States, just few days before, in this week itself, a district court from Montana, a state, it has passed the order first time and held that wherever there is a failure to meet the standards of climate change, then the concerned state would be liable. Generally, district courts do not indulge in that kind of act. It is rather left for the federal court. Nevertheless, this is the first time, just few days before, maybe 12th or 13th or 14th as such. Along with the book release, we are also launching a diploma in sustainable development and environment law. Rather, since chair was instituted, it was our dream, it was our desire that we shall also provide some kind of knowledge inputs to the society, not only confined to students, but it is open for all. And that's why since last 1.5 years or so, We have been after launching the diploma, and we are happy that diploma is being launched today. About the book, Mr. Adithya has spoken about the context. I also do not wish to go to in the content of the book. That is for readers to go through, that is for readers to read, as well as, if at all possible, inspire and act upon. Rather informally, we have been talking that environmental law books are available, plenty of books are available. But it is not only environmental law book, it is a handbook on international environmental law, an interface of international law and environmental law. Because any discourse of international law, international environmental law, has been vibrant, considering the developments in the field and the nature of the subject. There is a need to research, read, and write critically about international environmental law, policy, practice, and issues. This book brings together chapters written by academics, scholars, practitioners, and industry experts from Global South. This book is an attempt to view both international law and environmental law issues through an interdisciplinary approach. The contributors explore the key foundational principles, governance structures, environmental studies, international relations, politics, philosophy, and principles of international environmental law. This book is divided into 4 parts. The chapters discuss in detail the niche areas of international environmental law, including climate change, intellectual property, trade, technology, atmospheric protection, oceans and waste regulations, among others. The book shall be a good resource for advanced undergraduate and postgraduate students, PhD scholars, academics, and practitioners of international environmental law. Today, I want to shed light on crucial perspective that often goes unheard in discussions surrounding environmental law, the perspectives of the Global South as pointed out by Mr. Adithya. As we navigate the intricate landscape of environmental challenges, it is imperative that we recognize and amplify the voices from regions that have historically borne the brunt of ecological degradation and social inequalities. Writing about environmental law from a Global South perspective not only brings to light unique experiences, but also holds the potential to reshape our approach to conservation, sustainability, and justice on a global scale. The Global South encompasses nations that have long grappled with multifaceted issues, including poverty, lack of access to clean water, inadequate sanitation, and the disproportionate impacts of climate change. Writing about environmental law from this vantage point allows us to uncover the interplay between colonial legacies, economic disparities, and ecological vulnerability. It brings to the forefront stories of resilience, innovation, and community-based efforts to address environmental challenges in the face of adversity. One of the most impactful aspects of adopting Global South perspective in environmental law writing is its potential to challenge dominant narratives and biases. Traditional legal frameworks often stem from Western perspectives, which may not adequately capture the nuances of environmental issues faced by marginalized communities in the Global South. By writing about environmental law
through this lens, we can shed light on the intersection of cultural practices, indigenous knowledge, and environmental stewardship that have sustained these communities for generations together. Furthermore, embracing a global south perspective fosters a deeper understanding of the concept of environmental justice. We call it now even a climate justice. In many cases, environmental harm disproportionately affects marginalized communities, deepening social inequities. By documenting and analyzing these disparities in environmental impacts, we can advocate for policies that prioritize the rights of affected communities, ensuring that they are not only protected from harm but also empowered to participate in decision-making processes that directly impact their lives. Writing about a global south perspective also underscores the urgent need for international solidarity. Environmental issues do not respect geopolitical boundaries, and the interconnectedness of our world necessitates cooperation among all the nations around the world. By highlighting shared concerns and promoting collaborations, we can bridge the gap between developed and developing nations, fostering a sense of collective responsibility for the stewardship of this planet, Vasundhara, the earth. Writing about environmental law from a global south perspective is not just about rectifying historical imbalances. It is also about creating more holistic, inclusive, and effective approach to environmental conservation and environmental justice. It is about amplifying voices that have long been marginalized and recognizing the invaluable contributions of diverse communities in shaping sustainable solutions. As we strive for a more just and equitable world, let us embrace this perspective, listen to its stories, and together chart a path toward a more harmonious coexistence with this nature. Today, I stand before you as one of the editors of this work that voices many of these concerns. In an era marked by unprecedented global challenges, we find ourselves grappling with alarming consequences of unchecked environmental degradation. As we witness the rapid depletion of natural resources, the loss of biodiversity, and the intensification of climate change impacts, the need for a unified legal framework to address these issues on an international scale becomes more relevant, more important, and apparent than ever as such. International environmental law serves as a cornerstone in our efforts to safeguard the planet for current and future generations. First and foremost, our environment knows no borders. The interconnectedness of ecosystems and the shared nature of environmental challenges demand collaborations among all the nations around the world. The atmosphere, oceans, and wildlife are not confined by geopolitical boundaries, and thus our responses to environmental problems must similarly transcend national limits. Through international agreements, countries can come together to create standards and regulations that harmonize their actions, effectively preventing a race to the bottom where countries compete to exploit resources without regard for the greater good or public good. Secondly, international environmental law provides a platform for addressing global environmental emergencies. From climate change to plastic pollution, these crises require immediate and coordinated action. When nations work collectively, they can pool resources, expertise, and innovation to tackle challenges that no single country can effectively manage alone. Think of the Paris Agreement, an international accord that reflects a shared commitment to limit global warming. Such agreements demonstrate the power of collective action in facing complex environmental threats. Moreover, international environmental law reinforces the principle of environmental justice. Often, vulnerable communities and developing nations bear the brunt of environmental harm caused by industrialized nations. By ensuring equitable access to resources and opportunities, international legal framework can counteract environmental injustices and promote fairness in addressing ecological systems. Writing on international environmental law, it is essential for building a sustainable future. As researchers, scholars, and legal practitioners delve into this field, they contribute to a growing body of knowledge that inform policy decisions and shapes the course of international negotiations. Their work equips policymakers with the tools they need to design effective environmental regulations, allocate resources widely, and hold responsible parties accountable for environmental harm. In conclusion, international environmental law is not just an academic exercise. It is a beacon of hope for a planet which is in peril. By promoting cooperation, addressing global challenges, ensuring justice, and guiding policy, it offers us a roadmap towards a more sustainable world. But to achieve this vision, we must continue to write, we must continue to discuss and advocate for robust and comprehensive international legal framework. Our collective efforts today will determine the legacy which we leave for generations to come, and it is a responsibility we cannot afford to overlook. Dear friends, the book which is seeing the day today, which has been released at an auspicious hands of Honorable Justice Gavai sir and other dignitaries. It is not only the book as such. It is not only culmination of those writings, but as I have said that it is an emotional connect wherein the brainchild behind this was Mr. Adithya. He and his team burnt a midnight oil and worked laboriously, very hard, with great efforts, reading, editing, re-editing, rereading, sending those drafts to the contributors again and again, twice or thrice, and that's how this meeting the deadlines of a publisher even. So that was not the small task, small work, it was an Herculean task and Herculean work. So congratulations to all, the whole team, Adithya and his team. And we are more happy that this book has been released, moreover, at the hands of not only a judge of the Supreme Court, but rather the great visionary and humble human being. Sir, thank you once again so much, and we feel blessed by your presence, as well as thanks to all the dignitaries. Thank you so much.
Thank you so much, sir. With that, the time has come to launch 1-year postgraduate diploma in sustainable development and environment. I request all our esteemed guests to launch the program. would call on stage Assistant Professor Dr. Anand Raut to give a humble introduction about Honorable Shri Justice Bhushan Gavai, Judge Supreme Court of India.
Thank you, Richa. Good afternoon, esteemed dignitaries on the dais, off the dais, and lovely audience who have gathered here for the program. Honorable Shri Justice Bhushan Ramakrishna Gavai, a jurist of utmost distinction and integrity. Enrolled as an advocate in 1985, Your Lordship embarked on a career that led him to the Nagpur bench of Bombay High Court. Serving as a government pleader and prosecutor for the Maharashtra government, Your Lordship demonstrated his dedication to the cause of justice. On November 14, 2003, Your Lordship's journey took a monumental turn as he was appointed as a judge of Bombay High Court. A tenure spanning over 16 years saw him contribute significantly to the judicial landscape, fostering an unwavering commitment to seniority, integrity, and merit. His exceptional record of service culminated in his elevation to the Supreme Court on May 24, 2019. The Collegium's recommendation of Honorable Justice Gavai bore testament to his distinguished qualities, emphasizing not only his seniority, integrity, and merit, but also imperative of due representation in the highest court of land. Honorable Shri Justice Bhushan Ramakrishna Gavai's legal journey exemplifies dedication, wisdom, and steadfast commitment to justice. His contributions, both in upholding the law and advocating for public good, for example, in judgments like Vivek Narayan Sharma versus Union of India, 2023, Sudhru versus the state of Chhattisgarh, Union of India versus Unicorn Industries, etc., stand as a testament to the principles upon which our judicial system thrives. As we reflect on his distinguished career, let us be inspired by the legacy of Honorable Justice Gavai and the profound impact Your Lordship has made on the Indian legal landscape. Furthermore, he holds the esteemed position of Chancellor at Maharashtra National Law University, Nagpur, a role that speaks to his commitment to nurturing the next generation of legal minds and promoting excellence in legal education. In a testament to his unparalleled dedication and expertise, he is poised to ascend to the esteemed position of 52nd Chief Justice of India. This forthcoming responsibility reflects his profound understanding of the intricacies of law and his unwavering commitment to the principles of justice and fairness. His journey symbolizes pursuit of excellence and justice, setting as an exemplary standard for the legal fraternity and the nation at large. Thank you.
The Honorable Vice Chancellor of the Maharashtra National Law University, Mumbai, my dear friend, Dr. Dilip Ukey, respected Nitin Thakker, the President of the Bombay Bar Association, of which I am still a member. The other honorable guest, Ms. Els Reynaers Kini, Professor Dr. Anil Variath, Professor Dr. Salunke, all the members of the faculty, Shri Iyer, the President of the Family Court Bar Association, the participants in the conference, the members of the faculty, and dear students. A very good morning to you all. It gives me a great pleasure to be with you all this morning. As a matter of fact, Dr. Ukey and I have been associated since long, more than a period of 2 decades. When he was the Dean of the Law Faculty at Pune University, I had occasion to visit the faculty on a number of occasions and also deliver lectures to the postgraduate students. In fact, as a matter of fact, after my elevation to the Supreme Court, he was inviting me to the MNLU Mumbai for some function, but I think I was destined to come here for a conference which, as Dr. Ukey said, It is not, the book is not only of academics, but is also of emotions. Professor Adithya Variath very succinctly described the book. Dr. Ukey has recognized the efforts taken by Adithya and his team. And like the contributors and the authors, the subject of environment is also dear to my heart, and therefore this occasion is also an emotional occasion for me. As a matter of fact, when I was a lawyer, I did many pro bono cases for the environment, for the wildlife. Nitin bhai must be aware about the Bombay Nature and History Society, BNHS. So BNHS had filed some PILs in Nagpur with regard to the Pendse National Park, the illicit fishing in the Pendse National Parks, and I had a great fortune of appearing on behalf of BNHS in those petitions. Apart from that, as a lawyer, I had the occasion of arguing before the Nagpur bench with regard to rehabilitation of villages from Tadova National Park, and it's a matter of great coincidence that the last order with regard to the rehabilitation of the last village in Tadova, I had the fortune of passing that order when I was presiding over the green bench of the Supreme Court. I'm really happy to be with you all this auspicious occasion of the release of the Handbook of International Environmental Law, as well as the launching of the Sustainable Development and Environment Postgraduate Diploma course and the conference on e-waste, recycling and circular economy for sustainability. I'm really happy that the MNLU in association with Justice Pendse Foundation is launching this program on sustainable development and environment. As said by Nitin bhai, before an era of PIL began, Justice Pendse used to contribute for the cause of environment as a judge of this court. I had a great fortune of appearing before him in many matters here, and as a lawyer you hardly used to get any chance to argue before him, and if he received with a smile, you knew what is the fate of the case. I'm really grateful to ML Pendse Foundation for funding the chair on environmental law, for keeping the memory of such a great jurist alive. Friends, today we are gathered here to discuss and deliberate upon perhaps the greatest problems faced by the mankind in the history. Today, with the threat of global warming and increased loss of biodiversity looming over us, the need to create robust mechanisms to deal with the calamitous consequences is of primary importance. Climate change remains one of the most important challenges of our time. The phenomena adds considerable stress to societies across the world and brings about severe and often irreversible changes to our environment. Thus, from shifting weather patterns that create disturbances in food production patterns to raising sea levels that intensify the risk of calamitous seashore flooding, the consequences of climate change are global in scope and unprecedented in scale, therefore necessitating immediate and drastic action by the sovereign states. Famously, the International Court of Justice, in its advisory opinion on the legality of threat of use of nuclear weapons, noted that, and I quote, "The environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn." I unquote. These sovereign states both of the developed global north and the developing global south must cooperate so as to promote a supportive and open international economic system that would lead to a sustainable economic growth and development throughout the world, not merely for the present generations, but for generations to come. As it is always said that the resources that we hold are in trust for the generations to come, and we have no right to exploit them at the cost of the future generations. However, most negotiations at the international level are dominated by discourse that stem primarily from the global north, thereby pushing the global south to the margins of the international environmental debate. The paucity of literature on seminal legal issues from the perspective of the global south has hindered its efforts in canvassing its position at international forums. It is therefore my great privilege to be a part of the National Conference on Climate Change, Environment and Sustainable Development, and to launch a program on sustainable development and environment, and to release an important work, that is the Handbook of International Environmental Law, edited by two of the eminent jurists, Professor Dr. Dilip Ukey and Professor Anil Variath. The genesis of this book lies in the establishment of the chair in environmental laws at MNLU Mumbai by the Justice M.L. Pendse Foundation. Professor Variath, who is the Registrar at MNLU Mumbai, was also designated as the first Justice M.L. Pendse Chair Professor in International Law. Professor Variath, in conjunction with Professor Ukey, the Vice Chancellor of the MNLU Mumbai, sought to initiate extensive scholarship in international environmental laws, which at that point of time was dominated by scholarships from global north. To plug this gap and to ensure that an India-centric approach is adopted while scrutinizing such laws at the international level, some of India's best scholars were invited to contribute to this handbook so as to ensure that the global south becomes an equal partner in driving policy discussions at the international level, and to move away from a Eurocentric approach. I am happy to note that the scholars from our neighboring states, such as Bangladesh and Sri Lanka, have also immensely contributed, so that the handbook provides a subcontinental lens in its analysis of the international environmental laws. The result of such endeavor is this handbook, which is expansive in scope and covers in substantive detail some of the most pressing concerns of today's environmental debates, be it a sustainable development or the conservation of biodiversity or climate change and its effects on indigenous populations, especially in the global south, or the conservation of oceans and oceanic resources, or the ice shelves in the Arctic and Antarctic regions, amongst others. The handbook must also be commended for delving into modern issues such as space debris and the pollution of outer space by defunct satellites, e-waste management, and the transportation and disposal of hazardous substances. That apart, the handbook includes several chapters where germane issues of legal responsibility and state liability are also discussed. This is important, for in this era of globalization, the efforts of an environmental catastrophe are not limited to the borders of one sovereign nation, but spill over to the other nations also. Thus, the fixation of liability becomes important. And when we discuss liability and claims for damages, we must also be told that the existing legal framework within such claims can be established. There are therefore several chapters dedicated to a critical discussion of the existing legal framework, the treaties from which it emanates, such as the Cartagena Protocol and the International Convention on Civil Liability for Oil Pollution Damage, amongst others. The dispute resolution process therein and the politics that engulfs the negotiations for these treaties. Another notable feature is the interviewing of allied issues in other fields, such as international trade law and intellectual property law, as well as international criminal law with international environmental law, and the attempt to understand the cohesive nature of the global legal regime that exists at present. There is also an interesting chapter on cryptocurrency and its impact on climate and environment. The handbook is comprehensive in its coverage of international environmental law and is notable for its emphasis on the social and political context in which the international environmental law has developed since the famous Stockholm Conference of 1972. The book's comprehensive coverage, attention to legal and political context, and emphasis on the role of the state actors within the present international law frameworks makes it an essential guide for the students, practitioners, and scholars alike. As all of us know that in the aftermath of Stockholm Conference, several international treaties and documents were agreed upon. The Convention on International Trade in Endangered Species of Wild Flora and Fauna of 1973 is another important instrument that seeks to control or prevent international commercial trade in endangered species or products derived from such species. By reducing the economic incentive to poach the endangered species and destroy their habitat by closing off the international market for such species. The World Charter for Nature 1982 proclaims certain principles of conservation by which all human conduct affecting nature is to be guided and judged, and provides that, and I quote, ecosystems and organisms as well as the land, marine and atmospheric resources that are utilized by man shall be managed to achieve and maintain optimum sustainable productivity, but not in such a way as to endanger the integrity of those other ecosystems or species with which they exist, unquote. The Vienna Convention for the Protection of the Ozone Layer is another multilateral environmental agreement signed in 1985 that provides frameworks for international reductions in the production of chlorofluorocarbons due to their contribution to the destruction of the ozone layer. Further, our common feature, also known as the Brundtland Report, was published in October 1987 by the United Nations and defined sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. The United Nations Conference on Environment and Development, also known as the Earth Summit, held in Rio de Janeiro in 1992, forms another pivotal moment in recent history which hopes to achieve sustainable development by reduction and elimination of unsustainable patterns of production and consumption, promotion of exchange of scientific and technological knowledge, compensation for adverse effects of environmental damage, adopting the precautionary and polluter pays principle, with environmental impact assessment as an instrument to monitor the likely environmental effects. UN Framework Convention on Climate Change of 1992 is another international effort to combat climate change by limiting average global temperature increases by stabilizing greenhouse gas emissions. The convention embraced the principle of common but differentiated responsibilities and is considered the parent treaty of the 2015 Paris Accord, which seeks to curb the increase in the global average temperature to well below 2 degrees centigrade above pre-industrial levels and pursue efforts to limit the temperature increase to 1.5 degrees centigrade above pre-industrial levels. The book's comprehensive coverage, attention to legal and political context, and emphasis on the role of the state actors within the present international law frameworks makes it an essential guide for students, practitioners, and scholars alike. I must therefore congratulate Dr. Dilip Ukey, Dr. Anil Variath, and all the members of the team, including Adithya Variath, for bringing out such a wonderful handbook which will be useful for the generations to come. When we talk about on the international level, the love for environment is deep-rooted in our culture. As one of the greatest saints, Sant Jnaneshwari, has said, Vrikshavalli ama sage sohere. The trees are like relatives to us. India, on its part, has always been a progressive when it comes to such issues. In fact, environmental protection has always historically been a part of our cultural values and traditions. In the Atharva Veda, it is said, and I quote, "Man's paradise is on earth. This living world is a beloved place of all. It has the blessings of nature's bounties. Live in a lovely spirit." The Jain Agams depict nature in a very unique way, as it says that 5 main elements of nature, Prithvi, land, soil, stones, etc., Jal, water resources including cloud, Agni, fire, Vayu, air, and Akash, that is the sky, are the living creatures and must be treated as living beings. In fact, our collective history reveals that emphasis laid on the protection of the environment is not merely anthropocentric but also ecocentric in nature. I will be failing in my duty to refer to an event occurred as early as in 1730. The king of Jodhpur had sent his army at a place called Khejadli in Rajasthan. The place had derived its name because it had plenty of khejri trees. The king wanted to construct a palace and therefore were cutting these trees. He had sent his army. But the villagers, under the leadership of Amrita Devi, they plugged they embraced the trees, and they said that if you have to cut the trees first, you will have to do away with us, then only the trees would be permitted. And under her leadership, 363 persons from that village, including her 2 daughters, lost their lives. But the last words that she used was, and I quote, "Sir saate par rook rahe, to bhi sasti jaan." A chopped head is cheaper than a chopped tree. Such is the love and affection for environment as back as in 1730. The Chipko movement under the leadership of Sundarlal Bahuguna in 1970s took an inspiration from the Khedlaji movement of Amrita Devi. We were one of the foremost participants in the Stockholm Conference, and in the aftermath brought about several legislations to protect nature, such as inter alia the Wildlife Protection Act 1972, the Water Prevention and Control Protection Act of 1974, the Air Prevention and Control of Pollution Act 1981, and the Environmental Protection Act of 1986, in consonance with the aims of Stockholm Conference. As Nitin Variath addressed, the Constitution was also amended in furtherance of the Stockholm Conference through the 42nd Amendment to expressly bring in directive principle, Article 48A, which casts a duty upon the state to protect and improve the environment and to safeguard the forest and wildlife of this country. In fact, Article 51AG was also inserted, whereby a fundamental duty was cast upon citizens to protect and improve the natural environment, which includes forests, rivers, lakes, wildlife, and to have compassion for the living creatures. We have also seen the Supreme Court in myriad decisions has created an enabling atmosphere for the protection of our environment. It is to be noted that the principles enshrined within these decisions are not novel, but stem from international treaties and reports. And therefore we see In the case of Maneka Gandhi, the Supreme Court went on to say that the fundamental rights mentioned in Part 3 are not exhaustive, but they are only illustrative in nature, and anything which emanates from the trinity of Article 14, Article 19 and Article 21 would be a fundamental right safeguarding the rights of the citizens. And thus, the Supreme Court on many occasions has stepped with the developments in environmental protection at the global level, frequently deploying the trinity of Articles 14, 19 and 21 in the quest to safeguard the environment. There is a long list, but I will only refer to few of the judgments. In the landmark case of Velar Citizens Welfare Forum versus the Union of India, the importance of both the precautionary and polluter pays principle was recognized. Both this stem from the Rio Convention, and to have it transposed within domestic environmental law speaks volumes of the Supreme Court's resolve towards the environmental protection. The principle of absolute liability in cases of industrial accidents now finds place in our jurisprudence through the Supreme Court's decisions in MC Mehta versus Union of India. In the series of MC Mehta cases, the right to pollution-free environment, the right to potable water, the right to so many rights have been carved out in the trinity of those three articles. We see that as even today, Delhi is one of the most polluted cities, but it is only because of the MC Mehta's case, the directions issued by the Supreme Court, that all diesel vehicles were directed to be removed from Delhi, and therefore to some extent the pollution levels have reduced. So also the polluting industries within the NCT of Delhi were directed to be removed from the area, thereby reducing the carbon imprint. The doctrine of public trust and protection of the commons is another principle that has been followed from time to time, as was held in Association for Environment Protection and State of Kerala. Natural resources including forests, water bodies, rivers, seashores, etc. are held by the state as a trustee on behalf of the people, and especially for the future generations. These constitute common properties, and people are entitled to uninterrupted use thereof. These principles thus echo the international principle of intergenerational equity, which has become an important limb of international environmental law. In another MC Mehta case related to Taj Mahal trapezium zone, popularly known as TTZ, on observing the damage caused by gases like sulfur dioxide emitting from the nearby chemical factories and refineries, which resulted in acid rain, the Supreme Court applied both the precautionary and polluter pays principle and directed the industries which are not in the position to obtain gas connections to stop its functioning with the aid of coke, coal in TPZ and relocate themselves. I was fortunate enough to be a part of the bench passing various directions in the TTZ case. In rural litigation, Environment Kendra versus the state of UP, acting upon a letter detailing a reckless and illegal mining operations that had reduced forest cover in Mussoorie Hills, the Supreme Court directed operations of the most dangerous mines to be stopped and urged the relevant authorities to consider environmental concerns and implement adequate safeguards when granting mining leases. Coincidentally, the past Chief Justice of India, Justice Lalit, was appointed as an amicus curiae in those cases when he was a lawyer. The Supreme Court observed that the preservation of environment and keeping the ecological balance unaffected is a task which not only governments but also every citizen must undertake, as it is a social obligation and fundamental duty of all the citizens under Article 51 AG of the Constitution. In Yes Jagannath versus Union of India, observing that the traditional rice shrimp rotating aquaculture system previously used by Indian fishermen had begun to give way to more intensive method of shrimp culture, with more than 80,000 hectares of land having been converted to shrimp farming. The court considered various studies that documented issue of loss of agricultural and land and mangroves, obstruction of natural drains, salinization, destruction of natural seed resources, use of drug and chemicals, extraction of groundwater, and loss of biodiversity. Taking into consideration all these factors, the court directed constituting an authority to protect ecologically fragile coastal areas and held that agricultural lands, salt pan lands, mangroves, wetlands, forest lands could not be converted for construction of commercial shrimp culture ponds. Recently, Dr. Salunke has referred to the case which was decided by us about 2 years back regarding the Sukna Lake. A huge housing complex was sought to be constructed adjoining Sukna Lake within the boundaries of protected area, and we prevented that. Recently, I also had an occasion of hearing a matter concerning the Carbusian heritage of the city of Chandigarh, wherein rampant apartmentalization in phase 1 not only deviated from the city planning but also caused a strain on available resources. So while preventing that, we also passed directions to preserve the heritage status of the city. We undertook an analysis of the effects of rampant controlled urbanization, as was the case with the city of Bengaluru, which had seen the entire flooding on account of encroachment on the lakes, and appeal to the legislature, the executive and the policy makers at the center as well as the state levels to make necessary provisions for carrying out environmental impact assessment studies before permitting urban developments. Further, in the continuing mandamus, that is the case of N. Godavaranam, Thirumpala versus Union of India, numerous directions have been issued to ensure protection of forest cover and prevention of illegal deforestation operations. From last November, I am fortunate to head the Green Bench that regularly hears these matters, and recently we had pronounced order with regard to fixing the minimum areas of eco-sensitive zones and protected areas. By an earlier order, the court had directed a uniform 1 kilometer as ESZ, but many of the states found it very difficult because you also have to be practical. It is difficult or impossible to have an ESZ of 1 kilometer for Sanjay Gandhi National Park because you have all the buildings within 50 meters or 100 meters. The Raj Bhavan at Chennai, Madras, is situated within the area of Gundi National Park, and therefore we had to say that the studies would be undertaken by an experts committee appointed by the Ministry of Environment and Forest and Climate Control, a committee consisting of around 14 members, and they will examine each and each case independently and provide an ESZ for a particular sanctuary depending upon the circumstances existing therein. However, while directing that, we issued a direction that though ESZ would be flexible, but no mining activities would be permitted within a period of, within a distance of 1 kilometer from the boundaries of the protected forest. Otherwise, this would lead to nothing else but than a death trap for the wildlife. Then, there is always a question of man-animal conflict, the conflict between the sustainable development and the environment. And for that, we always have to find out the practical solutions. When I was at Nagpur in 2016-17, there was an issue with regard to the national highway which connects Nagpur to Jabalpur. Mr. Deshpande is there, he is aware about it. Yeah. So, on one hand, we had a difficulty that it passes through the Pendse National Park in Madhya Pradesh as well as Maharashtra. So, there was a problem as to if the NH is developed, 4 lane is made, then there would be a problem for the wildlife. The wildlife would not be in a position to cross. The tiger would not know the boundaries of a road. For it, the forest is the same. And therefore, we issued certain directions. And as a pilot project, the underpasses of the width of about some underpasses having a width of 1.2 kilometers and some underpasses having a width of more than 500 meters were provided. And we also issued directions that the height of the underpasses should be such that when a wildlife animal sees the other side of the road, he should feel that the forest is in continuity. He should not feel that there is a barrier. And if you happen to go to Pendse National Park, you will find that it has been a very nicely developed both on the Maharashtra side as well as the Madhya Pradesh side. There is a protection for the wildlife. The wildlife can freely move from one part of the forest to the other part of the forest. So also a road is provided so that the citizens can commute between Nagpur and Jabalpur. So, and now that is a role model. So wherever national highways are passing through the protected forest areas, the underpasses or the overpasses are mandatorily provided for, like the Samruddhi Mahamarg, which is connecting Nagpur to Mumbai. Various underpasses as well as overpasses have been provided wherever the national highway, the Samruddhi Mahamarg, passes through the protected areas. Then another one issue is with regard to, we find that most of the gods find a place of abode in the midst of the national parks, and the devotees throng in thousands to visit the deities, and it was difficult how to resolve these issues. So there is a famous Hanuman temple in the midst of the Sariskar Tiger Reserve, and thousands of pilgrimages on Tuesdays and Saturdays throng to the place, and they come in jeeps and they come in motorcycles, thereby causing a very serious threat to the wildlife. Therefore, as a pilot project, we have issued directions that no vehicles would be permitted, and an NGO has provided with 20 e-buses. So all the devotees will be taken from the gate of the national park to the temple in the e-buses, so that they can't throw anything out of the bus. And so such sort of solutions are to be found out, because you can't prevent a man. They have belief of years and years, hundreds of years, thousands of years, and at the same time you also need to protect the environment, the wildlife. It is thus clear that nature and its protection is not simply the prerogative of a responsible state, but also of a responsible citizenry. In the context of international environmental law, it must be kept in mind that such a concomitant duty rests not only with the sovereign states, hegemonic in nature, but also of the global human population. After all, without nature's providence, no state would exist, nor would the global population be able to enjoy the fruits of progress in the manner in which it enjoys at the present. We are seen every day in the TV as to what is happening in Himalayas, and therefore we need to be very sincere about our efforts with regard to protection of environment. This brings me to an important point: how do we reconcile the protection of the environment with the development needs of the global south? As a developing country ourselves, emphasis on equitable sustainable development cannot be overlooked. While often nature and development are framed to be at loggerheads with each other, the past experiments, whether on the basis of directions of the court as highlighted above or otherwise, have shown that it is indeed possible to promote human development and ensure environmental protection at the same time. For instance, the habitat and meadows development as pioneered by Professor G.D. Muratkar from Chikaldara in Maharashtra. The grass, who is known as the grassman of India, he has developed the huge meadows initially in the Melghat Tiger Reserve, and which was a role model and is being followed in now most of the national parks, most of the tiger reserves. And this has helped in increasing the herbivorous animals and thereby reducing the conflict of human and wild conflict. If the population of herbivores is enough, there is no need for the carnivores to travel outside their territories, and such initiatives need to be taken note of. The responsibility to be apportioned for climate change initiative has been a primary bone of contention between the global north and the south. After all, the global south's first line of attack has always been that climate change is a direct result of the actions of the global north. Nitin Bhai just mentioned that 10% of the American population is responsible for 40% of the carbon. Insofar as that it has benefited from the economic development and the resultant rise in emission and onset of climate change. Thus, to impose an equal responsibility for climate change upon the global south would be to rob it of the opportunity to industrialize and become part of the global north. In fact, as many of you would know, the inclusion of the common but differentiated responsibility principles in several international conventions was quite controversial, in that it faced opposition from the global north. This principle recognizes the unequal contribution by states to environmental problems as well as the disparate ability of states to address these problems. Additionally, the Rawlsian principle of intergenerational equity too has been criticized by the global south, whose nations tend to focus on the concept of intra-generational equity in as much as inequities amongst the current generations must be addressed before intergenerational equity is discussed. For instance, it cannot be that an ordinary family in Eritrea or Ghana in Africa must bear the present effects of climate change when the benefits of development have yet to reach them. As a corollary, it cannot be that a family in the United Kingdom or the United States is allowed to enjoy the fruits of development and yet not bear the effects of climate change to the same extent as a family of Eritrea or Ghana or in India. In other words, much discontent exists between these nations such that consensus on several pressing issues is hard to achieve. This conference comes at a timely moment, for we are living in an age where the most pressing issue is that of environmental protection. It should come as no surprise that the brunt of climate change and loss of biodiversity will be faced by developing and low-income nations. And thus, it is incumbent upon these nations to drive the conversation on such vexed issues forward. The conference and the handbook itself, therefore, shall serve as a guiding light for the nations of the global south when negotiating with the nations of the global north on the aforesaid contentious issues. After all, the UN Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services reports warn us about the possibility of extinction of almost 1 million species in the decades to come. Today's youth is especially cognizant of the need for environmental protection and are leading the fight against climate change. As a living document, our Constitution has come to encompass the principles of living in harmony with nature and has been so interpreted in reference to our fundamental rights and duties. collective actions and global efforts, as well as individuals' actions in adopting sustainable practices in the need of the hour, with massive strides being made in the field of green energy as well. It rests upon us to learn, understand, and pursue such various alternatives. I am happy that today we are also launching a postgraduate diploma on sustainable development and environment. For the future, it is a very important topic. The new generations must know how to balance the sustainable development with environment. I am sure that this course, in the memory of Justice M.L. Pendse, will go a long way in producing students who would be our ambassadors for protection of the environment. As far as my association with the university is concerned, as Dr. Ukey mentioned, that though I am the Chancellor of only Maharashtra National Law University at Nagpur, but I publicly in my speech when our phase 1 project was being inaugurated at Nagpur, we were quite often criticized that Nagpur is getting a special treatment as well, and the Aurangabad and Mumbai are getting state motherly treatments. But I said from the dais that hereinafter I would request the government to pay more attention to the Bombay University as well as Aurangabad University. And now, fortunately, Aurangabad University is also developing well. I had an occasion to inaugurate I had an occasion to visit. I think Dr. Ukey was also there for that function in Aurangabad University, wherein certain courses were launched, as well as the foundation laying of certain buildings was also done. So therefore, friends, I see the students here. I would only appeal to them that one day you shall be helming the movement towards a more sustainable future. To the conference attendees, I hope that the scintillating discussions that you shall be partaking in provide you with new and exciting ideas on how to approach environmental protection. Professor Ukey's and Professor Variath's insight and expertise, combined with the contributions of other experts in the field, will be helpful for the participants seeking to deepen their understanding of international environmental law, its historical underpinnings, its philosophical foundations, and its present relevance. I am sure that the scholarship exhibited within the handbook and the discussions that will take place throughout the course of this conference will have a positive social impact, promoting a keener understanding of environmental law and its international dimensions. I once again congratulate Dr. Dilip Ukey, Dr. Variath, as well as Adithya and all their team for bringing out such a wonderful handbook. I wish a grand success for the today's discussions in the today's conference. Thank you very much.
Thank you so much, sir. Now I'd like to invite Dr. Jijimon, sir, Associate Dean, MNLU Mumbai, for vote of thanks.
Honorable dignitaries, esteemed invitees, friends from the legal fraternity, and dear students, very good afternoon to one and all. Thank you is a gratitude which is felt by heart and mind, and I feel privileged and honor to get an opportunity to thank and propose vote of thanks on this special occasion. I extend my heartfelt gratitude for all your presence at this momentous book release on a handbook on international environmental law, a significant contribution to the legal realm of legal scholarship and the launch of the postgraduate diploma in sustainable environment. We are honored and privileged to the august presence of Honorable Justice Shri Bhushan R. Gavai, Judge Supreme Court of India, as a chief guest for today's function. His Lordship was kind enough to accept the invitation and grace the occasion. with his illustrious, insightful, and thought-provoking words. We are deeply indebted to our Lordship for being a mentor to the university and for all the help that your Lordship has done for this university. And on behalf of the Vice Chancellor and MNLU family and all present here, I express my sincere gratitude to your Lordship. Thank you, sir. Thank you very much. Our Vice Chancellor, Professor Dilip Ukey, who is an inspiration and soul of the university, has always guided us and led us from the front. His exemplary academic, research and administrative experience and visionary insight has placed MNLU Mumbai as the most desired national law universities in India. We thank you, sir, for your dedication, sincere efforts, and do continue, keep inspiring all of us. Thank you very much, sir. Shri Nitin Thakker ji, Senior Advocate, Bombay High Court, has supported us generously in all initiative of the university. I thank you, sir, for your continuous patronage and for delivering the guest of honor address in the function. Thank you, sir. I also place my sincere thanks to the guest of honor, Ms. Els Reynaers Kini, partner, Kini Law Firm, Mumbai, for her valuable presence and scholarly remarks. Thank you, ma'am. Professor Anil Variath, Registrar, MNLU Mumbai, is a person who has contributed from the day one of this institution. We thank you, sir, for being a pillar of power for all of us. Thank you very much, sir. Let us also thank, applaud, and appreciate the contributions made by various authors for the book on Handbook on International Environmental Law. I also thank all the respected delegates for taking their valuable time out and ensuring their presence for this function. Lastly, I thank Mr. Adithya Variath, Ms. Manisha, Ms. Mavish, and Ms. Richa, and all other members of the Justice ML Pendse Chair on Environmental Law, and all my colleagues, my HOD, my staff, who have been involved in organizing this event. Without their cooperation and support, this function would not have been possible. In closing, let us continue to be vigilant advocates for the promotion of our environment through informed and compassionate action. The Handbook on Environmental Law stands as a testament to what can be achieved when knowledge and dedication converge. Thank you all once again for being part of this auspicious occasion. Jai Hind.
Himáchala Yamuna Ganga Uchala Jalati Taranga Tava Shubha Name Jage Tava Shubha Ashish Mange Gahe Tava Jaya Gatha Jana Gana Mangala Dayak Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 He